Undoubtedly, we spoke, I don't know, sometime over the past couple of years, maybe multiple times over the past couple of years, about a case that is no longer relevant called Friedrichs. And this was a case which involved I believe it was a California teacher who was claiming that she didn't want to pay her agency fees. These are the fees that are paid to a union when you don't want to join. And you don't want to pay for their political activity, but you've got to pay for them to represent you because the law says that the union has to represent you, and so they deserve to be paid for their work. She was saying this was an infringement upon her rights, and it looked like public sector unions were in big trouble. And then, for those people who believe in a higher power, and Scalia exited his bodily form on this planet and saved public sector unions, in among other things. But we have a new case, and this is Janus v. AFSCME. There were oral arguments this week. I know that you were following them quite closely. Tell us about Janus, and tell us what's going on with these oral arguments, and what are the implications of this case?
Sure. So, I mean, that unions were saved when Republicans lost their majority on the Supreme Court, and now it looks like they just got a stay of execution. So the issue here that, like you said, if you work in a unionized shop, the union has to represent all of the workers in the unionized workplace, regardless of whether those workers choose to join the union or not. And there's a ton of benefits to working at a unionized shop. On average, unionized workers make about 12% more than non-unionized workers. So typically what happens is that unions will try to bargain for an agreement that says that if you don't want to join the union, you don't have to join the union. You actually have a constitutional right not to join the union. But you do have to reimburse the union for the fair share of the bargaining and the grievance management and all of the benefits that it provides to the non-members. And that's what these agency fees are. What this Janus case is trying to do, what the Friedrichs case tried to do 2 years ago, is say that for public sector unions, these agency fees are unconstitutional. And it's a rather silly and rather aggressive theory of the First Amendment they're using to get there. And now that Republicans have their majority back on the Supreme Court, it looks all but certain that the unions are going to lose this case.
Let's talk about that theory around the First Amendment. If I understand it correctly, the argument is because these are public sector unions and they are negotiating with a government entity, maybe it's a county, maybe it's a city, maybe it's a town, maybe it's a state, that they are going to, whatever amount of money they get is going to come out of tax dollars, and therefore it is a sort of a political act that they're doing. And if I'm a member of a union, and I don't think government should spend much money, but I also am, but then the union in negotiating my contract is actually forcing me to adopt a political position that I don't want. Is that the argument? Because it sounds bizarre.
Well, so basically what the plaintiffs are trying to do in this case is they're trying to blur the line between the way that the Constitution treats, or the way the government's allowed to treat its employees and the way that the government's allowed to treat the general public. So, like, if the government came to you and said, Sam, I am ordering you to teach a lesson on To Kill a Mockingbird, that's not something that the government can force you to do. The government can't force you to speak against your will. But I was once an English teacher, and I worked for the government when I was an English teacher. And the government had every right to order me to teach To Kill a lesson on To Kill a Mockingbird, because that was my job. So the First Amendment has a lot of things to say about what the government, general public. It has many fewer things to say about what the government's allowed to do to its employees. The government can fire government employees potentially if they say something in certain context that goes against the message that the government is trying to convey. So that's just the way that things work. It's like the Supreme Court has always recognized that the government has employees. It needs to be able to manage the workplace just like any other workplace. And so the First Amendment just functions differently in the workplace context than when it does when the government is regulating people as individuals.
Right, of course, because you can't have the government have less ability as an employer than people in the private sector have as employers.
Right. So in the theory here is that if the government were to force someone to advocate on behalf of whatever a union wants to advocate for, that would be illegal. And so in theory, it is also illegal for the government to make someone contribute money to the union. There's actually a lot of problems with that legal theory as well. Taxes people, and it spends at least some of those taxes on communicating messages that you and I might not agree with. In the 1980s, you had the Just Say No campaign. Maybe you or I don't agree with the message conveyed by the Just Say No campaign. Tough. We still had to pay our taxes. But anyway, it's a very
well. I also, like for instance, the government the state government forces me to get car insurance, and I have little doubt that these insurance companies who I'm forced to pay aren't advocating for things from our government that I disagree with.
Right. Yeah, and that's just another example, right? So the government can say to you, you must buy car insurance, and the car insurance company is then allowed to take the money it collects from you and lobby. Not only is it allowed to take the money it collects from you and lobby the state, it's allowed to take that money and lobby the state to pass a law to force you to buy more insurance.
Right.
This theory that they're arguing in Janus doesn't really make much sense if you think about its implications for other cases. And at the oral arguments, what you heard from the liberal justices was a certain exasperation with this. They kept giving examples about, well, what about this case where people could have to contribute? What about bar associations where you can't practice law unless you contribute to a bar association? What about student activities fees, where if you're a student at a public university, you may have to pay into a general fund, and then that fund may bring in a speaker you disagree with. So this is something that happens all the time. And what the impression I got from the Republican justices, at least the three that actually spoke, is that they didn't really want to engage with those problems. They just want to create a good for union tool. They don't like unions. They're going to create a rule that will be bad for unions here. And then they'll just come up with some excuse to distinguish the other cases.
I mean, that is, and I know, and we've spoken many times in the past about the Supreme Court, but that is an incredibly cynical perspective, one that I think is also probably dead on. Like they're going to fashion a principle that is going to be narrowly tailored to just people they don't like, essentially.
Yeah, I mean, this is the Bush v. Gore of First Amendment. Like Bush v. Gore, right. You'll remember, is 5 justices decided to elect George W. Bush. So they wrote an opinion explicitly that, this legal reasoning is good for this ride only. And what's funny about the legal reasoning in Bush v. Gore is, in that case, it led to George W. Bush being elected. But a lot of it was actually really progressive and would have led to very progressive outcomes in a lot of election cases. And nope, you're not allowed to use it for those cases. You're only allowed to use it to elect George W. Bush. It's the same kind of case here.
Are they going to, well, when we come back, let's take a break. When they come back, I want to know, is this going to spur other lawsuits to sort of test that theory as to whether or not, we can get out of paying for stuff if that stuff is going to be used to support public, speech that we don't like, particularly when it's the government forcing us to pay for this stuff. And also, I'm curious as to what's going to happen with appellate judges and judges on the federal judiciary who are not at the Supreme Court? Are we going to see how they're going to react to that? And then we're also going to discuss this ruling that took place in the Supreme Court in the Rodriguez case, which I find just absolutely stunning, and it has to do with indefinite detention. We're going to take a quick break. We'll be right back with more. I'm Sam Seder. This is Ring of Fire Radio.